Shalom, friends. Good evening from Jerusalem. Good morning, wherever you are, whether it's California or elsewhere, New York, or elsewhere in the world. I don't know whether Ian Morris is connecting with us from Australia or elsewhere, and some from Israel, which is always wonderful. This is going to be both an amazingly interesting, clear, compelling presentation and an important one. And the two don't always go together. But let me just preface the introduction of Professor Suzie Navot with the good news about the next two installations in our webinar series, so that you can save the date. We are privileged to have in a month's time, on March 13th, the former Deputy Chief Justice, Professor Eliakim Rubinstein, who is going to be presenting an angle which is not much covered. And I urged him to do that, and I'm glad to say that he was willing to take on the challenge. We have lots of accounts of the war, whether the previous webinar that we held about the court in The Hague, and there is lots of accounting, detailed accounting, and experts providing us with insights as to the legal aspects of the war and in the international context and beyond. I asked Justice Rubinstein to share with us the dilemmas, the Jewish dilemmas and the legal dilemmas that are faced by someone like him, having served as Israel's Attorney General and Deputy Chief Justice, and being a true scholar in the area of Jewish law and Jewish ethics. So that's going to be in a month, and in 2 months, on April 9th, we'll have, again, Rabbi Professor Dalia Marks sharing with us another exciting, unique aspect of the reality of these months, namely the new liturgy and rituals that have developed since October 7th. And there is quite a bit of creativity, much of it challenging, spiritually and religiously challenging, some of it quite comforting, and I'm sure you'll be interested in hearing her expertise on all matters of liturgy. So for today's program, and I urge you during the presentation to raise questions, make comments on the chat. We'll try and address them to the best of our ability. And even if we don't manage to address all of them, I know that Professor Navot will be responsive if we share it with her afterwards. And it's important that that you make the most of this very important presentation. So Professor Navot is Vice President of the IDI, the Israel Democracy Institute, and a renowned scholar in the area of constitutional law. And she has been a leading figure in the Israeli media, a sought-after commentator on television and radio even before she joined IDI. But with IDI and the amazing work that they do, and I really want to make a pitch for the excellent website, the excellent presentations, the excellent articles, and the excellent social research that they are doing in the Viterbi Center for Social Research. do take advantage of it, and Suzie Navot is really one of the key stars because she combines the scholarship with a unique and very, very impressive capacity to present complex issues. She spoke with us about a year ago about the threats of the judicial upheaval, the legal upheaval, and I think that we have seen everything she said materialize in the subsequent months until it was a contributing factor in causing us the catastrophe of October 7th. But that's not the topic she's going to be talking about. She's going to be talking about something that ironically was just further attested to by the Moody's rating institute or agency that as part of its economic thorough account of where Israeli economy is and why Moody's felt the need to downgrade its rating, one of the things that stand out in the Moody's report is the importance they attach to the authority, the independence, and the role of the Supreme Court in safeguarding Israeli democracy, which stands out especially given the very critical note that they use when they describe the executive and the legislator. So in the last few weeks, there have been some landmark decisions of the Supreme Court that deal with what Professor Suzie Navot raised as a question. Is that heralding a new era in Israel's constitutional law? Well, I don't know. We'll hear from her. So there have been a number of landmark decisions, and Professor Navot will share with us the essence of those decisions. This is not meant for lawyers only. This is a popular presentation, but this is the time to acknowledge our partners. And I'm glad to see Steve Greenwald, the past president of the AAJLJ, the American Association of Jewish Lawyers and Jurists, our wonderful partner. And as I said, the co-chairs of JPLAN, the Jewish Pluralism Legal Action Network, and Rabbis for Religious Freedom and Equality, quite a number of whom are here on the call. So, Professor Navot, the microphone is yours.
Okay, thank you very much, Uri, and hi, Steve, and hello, everybody. We've met, I don't know, you said a year ago, it seems ages for me. I will give you, before I start speaking about those cases, I will take a few minutes, perhaps even less than 5, to give you a brief reminder, short background of Israel's constitutional, I think, law or Israel's constitution, so we can start all from the same point, even if you are not very well, if you don't know exactly what's going on. So I am sure you all know that we do not have a single document known as the Constitution. We should have, but we don't. With the establishment of the state in 1948, our Constituent Assembly was supposed to write a constitution, but the Knesset discussions on the matter failed. And in 1950, a decision was made in the Knesset according to which our constitution would be written in stages, by stages, chapter by chapter, like you take a salami and you cut pieces of it. The only actually country in the world with a constitution by stages. And all the chapters of the constitution will be called basic laws. And as those two cases that Uri said deal with basic laws, so I have to explain you about it a little bit. They said in 1950 that when all the chapters of the Constitution will be finished, all the basic laws will become Israel's Constitution. But our founding fathers, if my if I may call them like this. In 1950, they just forgot to tell us two things. First of all, how long should it take to finish writing those basic laws? 6 months, 1 year, 2 years, 5, 10, 75 years? And the second question they did not answer is, what is their legal status? What is their legal position? Are these regular laws until all the project is finished, meaning that any law by a simple majority may change them or amendment? Just imagine 3 members of the Knesset coming in after all the time it takes to get to Jerusalem and said, okay, we live in the south. We are really tired of traveling to Jerusalem every day. Let's move the capital of Israel from Jerusalem to Dimona, and it's going to be much easier to get there. Okay, so if it's a regular law, you can do it just by passing another regular law, call it Basic Law Dimona, the capital of Israel, and in, say, 1 day, it's done. So we do not know the answer to these questions. Now, this compromise regarding the Constitution is still with us in this very day. Over the years, we have already passed, Israel has already passed several basic laws. Okay, the Knesset, mainly basic law deals with our institutions. We have basic law on the Knesset and on the government, the army, which is very important, the judiciary, the president, and some more. And in 1992, 2 basic laws also in human rights were adopted. Basic law on human dignity and freedom, and basic law, the freedom of occupation. But it was the Supreme Court of Israel which gave the basic laws their constitutional status. Still, until today, it's very easy to enact them, and they can be easily amended. This is not a real constitution, the one that you see in all countries. Basic laws can be passed by a simple majority and a small number of Knesset members without any constitutional discussion, without any comments, for example, from the academia, in a short time, without having broad consensus, with immediate effect, and even for personal reasons. They do not need to be approved anywhere else. We do not have a second House of Parliament. We do not have a president with a veto power. There's no special procedure to enact it. There are even no time limits between the readings. So you can pass a basic law, which is a chapter of the Constitution, let's say in 2 days. We have nothing. And this simple procedure makes Israel an exception when you compare it with other countries. We do not have a basic law which regulates the proper procedure. For example, a 2/3 majority to pass a basic law. In the US, for example, in order to prevent the, I think, arbitrary changes, the process for making amendments to the Constitution is very difficult. An amendment might be proposed only by a 2/3 vote on both houses of Congress, or 2/3 of the states request an amendment, and it should be by a convention. And the amendment that is proposed, in order to become part of the Constitution, it needs to be ratified by 3/4 of the states, meaning by 38 out of 50. You know how long it takes and how difficult it is. Well, in Israel, it's very, very easy. But still, this very fragile Constitution has constitutional status because it was granted by the Supreme Court, actually basing this decision on the case of Marbury versus Madison, the American case. Okay, and this fragile Constitution, these basic laws that are very easy to enact and to amend, limit the power of the Knesset. Because if a regular law infringes upon the rights that are written in the basic law, let's say, of human dignity, then the court may strike down the law and declare it an unconstitutional law. By the way, we may see it again, I think, actually very soon. If a new law is passed that will exempt again all yeshiva students from the army in days where we need more soldiers, and this law is, I think they're trying to pass it in the next few weeks, we may see again the Supreme Court striking down a law because it infringes upon rights, and then it's an unconstitutional law. But even if the Knesset is limited, still in Israel, and I think we'll finish there, in Israel, all you need in order to change all the basic laws is maximum majority of 61 out of 120 members of the Knesset. This is all you need in order to change everything: the law of return, the values of the state, the system of government, the Jewishness of the state, the democratic values of the state. A simple coalition majority in Israel, and only in Israel, okay, can change everything. And when the new government was established and the reform plan was presented, the judicial overhaul that you mentioned, Uri, it aimed, first of all, at taking control of the courts. And why the courts? Because the court, and especially the Supreme Court of Israel, is the only branch that may actually limit the power of government. And they wanted the court to be completely politicized. But as you well know, this reform proposal brought hundreds of thousands of Israelis to the street every day. And finally, out of this reform, the Knesset passed one of these laws, basic laws that they wanted to pass, one part of the reform in July 2023. And that was the amendment, we call it the amendment regarding reasonableness, the reasonableness amendment. First of all, why an amendment? Because it's an amendment to a basic law, meaning it's an amendment to our constitution. Which basic law they wanted to amend, when they did amend? The basic law on the judiciary. And what is the case about? This amendment actually prevents the Supreme Court from dealing with or overruling decisions made by the government, by ministers, or by the prime minister, on the basis that those decisions are extremely unreasonable. And I think that in Israel, you have to know that according to our case law, the court may check decisions made by ministers and also the government. For example, when the government or the ministers take decisions without a proper procedure, or they do not apply the proper considerations. Because in Israel, the government is required to act with reasonableness. And why reasonableness? Because the government is the public's trustee, and not just the public that voted for it, but the entire public. And therefore, it must act reasonably and in the public's interest. And the Supreme Court actually only intervenes when the decisions are extremely unreasonable. It means that they can make thousands of decisions, but only when the decision is extremely unreasonable. You know, they take a set of considerations that have nothing to do with the decision itself. Only then the court will intervene. And the real meaning of this amendment to the basic law was that the government and its ministers in the reform, they wanted to have a free hand in appointing and firing officials, mainly gatekeepers, such as the Attorney General, like Rubinstein. He was an Attorney General. I think you should ask him that. The Attorney General, the State Attorney, the Police Commissioner, the IDF Chief of Staff. And it means that the government, if it wishes, would have been able to appoint to these jobs any unsuitable candidate, if it wishes, including corrupted people. They wanted that the only criteria for appointing these people would be their loyalty to those who appoint them, not loyalty to the people. Instead of gatekeepers defending the public interest, we would perhaps have, I think, bodyguards who are loyal only to the ministers. So after the amendment to the basic law was passed in July 2023, by 61-0, meaning that all the opposition went out of the Knesset. After the amendment was passed, meaning the reasonableness was abolished, meaning that the court cannot intervene, petitions were filed to the Supreme Court. And the court heard this case in September 2023 in a panel of all the bench, which is in Israel unprecedented, not like US, where you have all the time the 9 judges. Here, the Supreme Court works with panels of 3, 5, 7, 9, if it's a petition for a judicial review of a law, 11 we've seen, 15 never before. It's the first case where all the panel, all the bench, all the judges were sitting together, and it was very, actually, they were very tight sitting next to each other because the table is not big enough for all of them. We had one case in the late 60s, I think it was 1969, and then we had 9 judges in the bench only, where all the 9 judges sat in a question that is very interesting, I think, especially to you. And the question was, who is a Jew? Who is a Jew only for the population registry? Is somebody that is not a Jew can be registered as a Jew, and that was a main issue then in the 60s, but 15, never before. So the bench was unprecedented. The hearing was historical, not because the court dealt with a basic law. We have seen before appeals against basic laws. For example, there were appeals against the basic law on Israel as the nation state of the Jewish people. But it was the first time in the country's history that the Attorney General, whose job is to represent the government, and he is the law for the government, and he's the one who actually represents the government in the court, the Attorney General, she, Gali Baharav Miara, it's her name, she actually joined forces with the petitioners, and she asked the court to strike down a basic law. It has never happened before. Now, the decision of this case was published on January 1st, but the story of the decision begins a few days earlier, because on December 27, we had a leak of the judgment regarding reasonableness. Yeah, you know, the main television channel, 8 o'clock, big time, okay. The journalist Amit Segal publishes, I have the decision. It's 8 judges versus 7, okay, 1 vote. The liberals against the conservatives, and due to the fact that 2 liberal judges were already retired, but still within the time that they had in order to write and sign their opinion, if they had retired, said the journalist, then the decision would have been the opposite. And the decision was to strike down a basic law. And for me, I think it was a shock. The very leak is unbearable. It goes against everything we know about the Supreme Court, against the ethos of the Supreme Court. It undermines the sense of what we call, I think, collegiality, I think it's the word, between the judges and the people who work with them. And it was an intended leak, because only some of the justice's opinion, of the judge's opinion, were referred to in this leak. And immediately the day after, there was a political initiative to postpone by law the date of the decision. Oh, no, we do not want this decision now, because we're in the middle of the war. But 5 days later, the decision was published. So the court, they actually finished writing what they had to, and they published this decision. And we got a decision that has 743 pages, 15 different opinions. And as I am in my office, in my home, I will show it to you. I think there's nothing, because you can see and not only listen. So I have it here with me. And that's it. I show it like this. Okay, so you can see, well, it's actually very heavy. I can let the door open and put it, and it will never close. It's a very, very heavy decision. And it took, I think it took me 2.5 days of reading, serious reading. There is not this, I cannot explain it all, but what I will do is I will refer to what I think are the 4 main issues, the 4 main questions on the court and what the judges said about it. And I think the first thing in Israel, the first question ever, dealing with basic laws, and if we remind ourselves of what I said before about this decision not to decide and the basic laws will be the constitution in the future, the first question is a theoretical one. Is our Knesset almighty? Or the Knesset, does it have the power to enact any basic law it wishes? Are there any limitations on the Knesset constituent power? Can they do anything they wish? I think this is a very important question, because the Knesset usually writes basic laws in order to avoid judicial review. And in the last years, we have seen actually an abuse of these basic laws. And the question is whether it's possible to write anything you want in a basic law. So if you understand the question, if the answer to this question is no, the Knesset, okay, is limited on its power to make basic laws. The Knesset has a limitation. Then we may move on and, okay, and ask a second question. What are the restrictions? Where are they written? Who enforces them? But if the answer of the judges is yes, the Knesset is unlimited. The Knesset has unlimited power to write anything it wishes in a basic law. Okay, basic law, okay, annulation of the state of Israel. Just imagine. If the answer is yes, then the case ends here, because the Knesset may do whatever it wishes with no restriction. Abolish the reasonableness, abolish the democratic values of the country, or even the Jewish values of the country, whatever it wishes. Now, the petitioners and the Attorney General, they all argued that there are limitations on the Knesset. When the Knesset enacts basic laws, there are things that it cannot do. It cannot deviate from the basic values of Israel as a Jewish and democratic state. That was the argument. It cannot deny the basic principles of a democracy, the separation of powers, the independence of the judiciary, the rule of law, free elections, human rights. Now, on this question, if we ask the judges, okay, what do you say about the unlimited power or the limited power of the Knesset when it enacts basic law? We get a response like this. 13 judges out of 15, they answer, yes, the Knesset is limited. But 2 judges in Israel, sitting on the bench today, they believe that the Knesset has unlimited power when it enacts basic law. These are Justice Solberg and Justice Mintz. And when they wrote that, the others, one of the others said, okay, I have some questions for you, my friend. Let me quote you just a very short paragraph from Justice Groskopf. He wrote to Justice Solberg. Justice Solberg is one of the 2 that says the power of the Knesset is unlimited. So Justice Groskopf says like this: in our system, the majority of the people cannot decide on the expulsion of the minority. They cannot decide on an arbitrary violation of individual rights. The majority of the people in the present cannot decide to be the majority also in the future. In a democracy like ours, the majority of the people cannot even decide on the replacement of their elected representatives except at the time of the elections. And these are only extreme examples of the limitations imposed on the will of the majority of the people. Say from now on, the will of the majority of the people is not omnipotent. And I think this is all the idea. Out of these 13 judges, they say the Knesset, out of these 13, 12 of them, only one is left home, 12 of them wrote that the power of the Knesset is limited, and we find the limitation in different, I think, different papers, in the basic principles of the state being Jewish and democratic, in the Declaration of Independence as a source, in the constitutional system. Okay, everyone goes to another place to find these core values, but everybody comes to the same conclusion. 12 judges decide that the Knesset powers is limited by the values of the state of Israel as Jewish and democratic. And this is very important because it looks at the future, no at the moment. Now we go to the second question. If there are limitations on this power, then the second question will be, okay, so the Knesset is limited. Who is going to enforce these limitations? Meaning, the Supreme Court has the authority, the power to strike down a basic law. Okay, who is going to be I think the policeman of this limitation? Who is going to enforce them? And in this question, in the second question, the position of the Knesset for me was very surprising. The government position was all time very clear. They say you have no power to interfere with our basic laws, and if the Knesset makes any mistake, the people will replace it. Don't interfere. Something like mind your own business. Okay? But the Knesset position, the legislative, was so very surprising in the court. They argued before the judges. They said that we in the Knesset, we think that there are very good reasons to argue that there is no power for judicial review of basic laws. No room for judicial review of a content of a basic law. But also in this question, 13 judges out of 15 said that the Supreme Court has the power to strike down basic laws and to enforce this limitation. And these two questions, in my opinion, are the most important for the future. Because it means that a large majority in the Supreme Court of Israel think that the Knesset is limited and that the court has the power to interfere and to strike down amendments to basic laws or even new basic laws. And it should be remembered that this authority, this power, is not written anywhere. And yet a large majority of judges, a majority that cuts across what we say conservatives and liberals, the big majority, the large majority believes that this power exists. And this statement is, for me, the most important in all the ruling, because, again, it's forward-looking. Now the Knesset knows for sure there is a limit to the power. You have limited power. That's the flag of these two questions. The third question is, okay, now the Knesset is limited and we have the power to strike down a basic law. Now let's go to the case. Is this the case to use this power? Is the reasonable amendment the extreme case to use this unconventional weapon? This is an amendment that undermines the basic principles of democracy? Perhaps it's not so bad. Okay. That's an amendment dealing with the reasonableness of the decisions of government is something that denies the character of Israel as a democratic state? The petitioner's argument, yes, of course, it is. And the Attorney General says, of course, it is. It denies the character of the state as a democratic state. And the court, here by a majority of 8 versus 7, stated first that the amendment creates a situation in which there is a law without any enforcement. The government is legally bound to act in a reasonable way, but the duty to act in a reasonable way is not or cannot be enforced by the Supreme Court, because the Supreme Court doesn't have the power to oversee, to check the government actions. And according to the majority, the amendment actually violates the principle of the separation of powers, the rule of law, gives immunity to the most powerful bodies in the country, which are the government and the ministers. The amendment puts the government and the ministers above the law. And according to the majority, this is a real serious violation of the principle of the rule of law and the principle of the separation of powers. Now, when you hear now what I told you, that this is 8 versus 7, then you may perhaps think, okay, the other 7 judges thought that the reasonableness amendment was amazing or completely legitimate. It's okay for the government to exempt itself from judicial review. Why not? But this is also not the case. And that's why the leak was so, I think, terrible for us. Out of the 7 minority judges, out of the 7 who said, we would not strike down this basic law, out of these 7, 4 of them say that they don't need to strike it down. They don't need. The amendment is very bad anyway, but we don't need it. We do not need to use the power to strike it down. Why? Because we will give this amendment such an interpretation that more or less will empty the amendment out of its contents. We can do interpretation. We can say that where it's written reasonableness, it's not written reasonableness. We can say that. And we will still review clearly unreasonable decisions of the government. They said, I have another way of getting to the same solution. So in a practical aspect, 8 out of 15, 8 versus 7 decide to strike down this amendment. But it's not really 8. Okay. It's 12 says, okay, we are not pleased with it. Okay. 8 of them say, okay, we will strike it down. And the other 4 said, okay, we do not need to strike it down. We can do it other ways. So in the practical aspect, first time in the history of Israel, and this is a presidential decision, the president is outstanding, because we now know that it's possible not only in a theoretical way, but also in practice. The Supreme Court of Israel has declared a chapter of our constitution unconstitutional. And I think these are the basic questions, but I want to add another one, because you spoke, Uri, before about the IDI and what we did on this case and or what we're doing. And I wanted to tell you something, I think from a personal point of view. There's the 4th question that for me is a fascinating question that has never arisen in Israel. And you know that the amendment on the reasonableness is a part of the reform. And the question is, should the court look only at the amendment that is in front of it? Or is the court allowed to look at the picture as a whole? Because we are living in a period of, we were living before the 7th of October, we were living in a period of constant struggle for the rule of law, for the values of democracy and the true separation of powers. And we all know what courts, I heard Judge and I see Steve, we all know that courts only discuss the matter before them. You lawyers, of course, know that. But the amendment on reasonableness was part of a wider set of constitutional amendments. So the question is whether the court is allowed to look at the whole legal reform, at the background of the basic law, at the intentions of the government, at the whole puzzle, and not just one piece of it. And this is a question that has been never argued before in court. And I haven't seen it in any other place in the world as well. So the petitioners said that it is impossible to ignore the fact that the amendment is a part of a coup, a coup d'etat, which has already begun. And the representative of the Attorney General, lawyer Hellman, he became of the Attorney General also. She also said that we have to look at other things. And he actually started when he presented his argument in court. He said like this: when the government says, trust us, that's the moment when you have to start being careful. Because otherwise, don't worry, we will not do everything. We will not. Trust us, okay? And what happened in this case, I had the opportunity and the pleasure of leading a team in IDI, and we wrote an opinion on the reasonable case, and we focused on this question, on the fourth question of the whole picture. Why? Because we conducted a comparative study, and we learned that limitation of the power of the courts and banning of judicial review, it's the first step of a populist regime. The governments in Poland and in Hungary, for example, they first established the takeover of the judicial system. And after that, acting against the media, the academia, the civil society, it's much easier. After you neutralize the court, after you capture the court, everything gets easier. And also we found that in comparative constitutional law, it's very difficult to find an example of one single constitutional law, which is the one that destroys democracy. I cannot see it in any country in the world. We call this phenomena backsliding democracy, democratic erosion, because damage to democracy is caused in a slow and gradual process. Each of the laws passed in those countries, for example, in Poland and Hungary, when you look at it on its own, it does not necessarily kill democracy. But when you examine all them together, you see the fundamental changes in the state regime, until the state is no longer a democracy. So changes in the legal system are one of the main tools used in the process of democratic erosion. Now, what happened in the decision? What did the judges say on this fourth question? Now, most of the judges did not address the issue at all. Mainly three mentioned it. There was Justice Wilner, Justice Kasher, and Justice Amit. Wilner and Kasher are one of the 7 judges in the minority, and they rejected the argument that the amendment should be looked against the background of the legal reform. She said, when we deal with the legal issue before us, there is no place to consider any ideas or proposals or legislations that have not yet matured. But what is very interesting, for me was very interesting, is that Justice Amit is the one to be the next president of the court, according to the seniority rule. He was the only judge in the panel, 1 out of 15, who actually listened to the argument. And not only listened, but he addressed it extensively. And let me quote another short paragraph. Slippery road, indeed, Maggie, you're right. And this is what he wrote. And he has a very, I like the way he writes his cases. He says like this, he writes like this: referring only to this amendment to the basic law is like a laboratory researcher who puts his eye to a microscope in order to examine a Petri dish placed under the microscope. This, ignoring the many Petri dishes already on the way in the table. Focusing only on one Petri dish under the microscope is like a blind man groping for the elephant trunk. Now, of course, the elephant in the dark, I'm sure you are well aware of it. And it may miss the overall picture. So actually, he allows for this idea to come into his decision. And although he was the only judge willing to consider the argument, at the end of the day, Justice Amit says, I don't need it. In my opinion, the present law by itself infringes upon so many democratic values. And therefore, I will leave this position, this argument, for further review in the future. and this is perhaps the closest position to accepting the argument for further review, is like saying, this is my position, this is what I think, it's possible, but I don't need it now. So to conclude this case, I think it's perhaps the most important landmark decision in Israel history. First of all, the Supreme Court affirmed first and foremost that there are limits to the Knesset power. And this decision focuses not only on this specific law, but on the unfinished business of completing our country's constitutional framework, finally defining the rules of the game. It was a very brave decision in dark times. Indeed, the label basic law does not give the Knesset immunity from the Supreme Court intervention. When the judges write that the Knesset is limited, between us, of course, they mean the government is limited. Because it's the government, unlike the United States, it's the government that in practice controls completely the Knesset legislation, with a heavy hand via its coalition majority. Okay, and the attempts to present the ruling as a thin majority, for me, these attempts are misleading, because the only truly important forward-looking questions, the majority is much more solid and far from being a division between liberals and conservative. So at the end of the day, the majority of the Supreme Court, I think the majority of the judges, they were willing to step up and defend Israel's democracy. And that's the first one. Second one, I will take only a few minutes on that. Uri, you didn't tell me how much time do I have, so just say go like this or interfere. Suzie,
that's
5 minutes and that's it.
Take 5 minutes to describe the other case, and then
yes, indeed, it will take 5 minutes because otherwise it's very.
As I said, you have the rare talent of bringing down to earth for the general public complex legal issues. So I haven't seen questions yet. So go ahead.
They're all asleep. No, I'm joking. I see you. I see you all, because I like when the cameras are open. I can, it's like talking to you, not virtually. Okay. The second rule, the second ruling was rendered a few days after these decisions. So when I finished reading the first one, I said, okay, I finished 743 pages. 3 hours later, I got the second decision of 212. Who said that the life of the constitutionalist professors are easy? Okay, so we got the decision of what we call the incapacity ruling. It, again, an amendment to a basic law, this time the basic law, the government, which actually limited the possibility to issue a decree of incapacity to the prime minister. And the decision of the court, 6-5, liberal versus conservatives. The decision of the court was to freeze, okay, like Frozen, like the movie, like the children like, to freeze this incapacity rule, this incapacity basic law. And this amendment will only take effect from the next Knesset, because it's an abuse of the constituent power. Now, it's a difficult case. I will do my best to make it as easy as possible. You know, in the basic law of the government, it was written that if the prime minister is incapacitated, meaning or prevented, or incapacitated or prevented from serving, then his deputy will fulfill his role. And nobody knows what the word incapacitated or prevented from, what does it mean? It's not written in the law when a person is incapacitated. So the Supreme Court over the years has said that not only medical or mental incapacity may be considered, but also perhaps a situation of legal incapacity, meaning that you are indicted. You have to go to court every morning. How can you rule a country? That's perhaps a legal incapacitation. So this is the ruling of the court. This is the case law. And after the judicial reform was presented, petitions were submitted to the Supreme Court claiming that Netanyahu, Prime Minister Netanyahu, he promotes changes in the judicial system while being an indicted person. He will change the way that judges are elected, judges that may be in his appeal. And this is against a conflict of interest contract that he has, and it's binding. So he's working actually against he's breaching a contract. So they went to the court and said, okay, declare that Netanyahu is incapacitated. And the coalition response to this petition was very quick. An amendment was passed 3 days before the deadline for submitting to the court the responses to the petition. What the amendment said, you can imagine. Incapacitation, okay, 2 points, purely medical. The legal incapacitation is gone, disappeared as it had never existed. So therefore, a petition was submitted to the court, and the petition was heard by a panel of 11 judges against the amendment itself, on the grounds that it's an abuse of the constituent power. It has nothing to do with the Jewish character of the state or the democratic character of the state. It's something different. You use a basic law in order to benefit yourself. So what is an abuse of this power to enact basic laws? According to the court ruling, this doctrine of abuse checks mainly whether it's a constitutional arrangement that is a part of the Constitution, or is something that is not a part of the Constitution because of the theme of it, because of the issue, or perhaps because it's temporary, or because it's a personal norm. So the main ruling of the majority described the legislative process as a personal law. The personal motive led all the proposal of the basic law. And like Justice Fogelman said, it colored it. It colored the entire procedure with the individual case of Prime Minister Netanyahu. And again, Justice Amit, I will quote again, because he also part of the majority, and he said, he uses the story of the duck. A law that was created for a person and reacts like a personal law and affects its environment like a personal law and proves itself through the legislative procedures that is a personal law, then it's a personal law if it works like a duck, and etc. So at the end of the day, the majority judges decided that the way to cure this constitutional defect is not to strike down the law, is to postpone the applicability of the amendment so it will take effect from the next Knesset after the election. And let me just perhaps take a closer look at the two cases together, because they deal with different topics. This is, okay, against the court. This is for Netanyahu. Do they have anything in common? So the incapacitation amendment wanted to give Prime Minister Netanyahu an exemption from his obligation to fulfill the conflict of interest agreement. Okay? A basic law was amended in order to exempt someone from his legal obligation, and of course to prevent the court from dealing with the issue. And now what was the purpose of the reasonableness amendment? Essentially, it was the same purpose exactly, to grant the government an exemption from its obligation to make reasonable decisions. So two amendments, two different basic laws, both with the same purpose, to remove restrictions so that those in power can act against the law, against the rules, and to prevent the Supreme Court from intervening. So to conclude, if we look at the future, Israelis can now be, I think, assured that for the moment, The Supreme Court justices will be there to defend democracy for as long as they're professional, I think, and political independence is maintained. But these decisions also raise another critical aspect, the important, I think, that after the war, we have to reinforce the constitutional rules. We have to place checks and balances of political power. We have to define the relations between the branches of Israel. And just to ensure that no simple majority ever may change Israel's Jewish and democratic character. Thank you.
Thank you, Professor Navot. You certainly met all the expectations. And the last few words, I think, have brought home the realization that this is not a legal history course or a chapter. This is really about one of the key existential constitutional challenges that is facing Israel. And as we described a number of times in the past, there have been attempts to subvert Israel's division of power between the judiciary, the legislature, and the executive. And to some extent, this has retrieved, as you have described, this has retrieved the ability of the court to fill its role in passing and applying judicial review, and make all of us, exactly as you said, feel much safer in terms of viewing Israel as what I think we all share in common, namely the unique character as a Jewish and democratic state. We are at times of war. Seeing the pin on your shirt and seeing the sign, the expanded dog tag behind you, clearly all of us feel that. But at the same time that we feel it, at the same time that we all live through it, whether we are in Israel or outside Israel, clearly the issues that face Israel as a Jewish and democratic state have not gone away. They are being discussed as we speak in the Knesset, they are being addressed in the media, and they are not going away anytime soon. So you have really helped us to understand one of the landmark junctions of Israel's constitutional law, and we thank you, and we hope it won't take another year before we have you back with us. And as I said, there weren't, we'll see. You know what? You look at the questions and see if there is a question. And in the meantime, I will repeat the amazing two next programs that we have. Next month, March 13th, and I'm sorry if I made a mistake and said March 14th. So March 13th, we'll have the former Deputy Chief Justice, Professor Eliakim Rubinstein, who was the Attorney General, and who is both a leading jurist and a scholar in Jewish law, share with us a unique perspective on the questions involving the war that are not addressed very often. So he will speak about the October 7th war viewed from a legal and a Jewish perspective, the moral dilemmas, the religious dilemmas that we need to address. And a month later, April 9th, we'll have Rabbi Professor Dalia Marks share with us a presentation and translation of some of the key works or key documents that have been written in terms of the new liturgy and rituals that followed the October 7th massacre and the subsequent war months. There are some amazing creative struggles with the spirituality and the liturgy and the rituals that the war has forced us to confront, and there is no one better than Dalia Marks to do that. So, next 2 months, be with us. Professor Navot, was there a question you wanted to address from what was written? other than thanking you.
No. Yeah, Brian made me laugh. He said, "Can we get you to help the United States Supreme Court?" I'm sorry, Brian. It's very nice. And David, let me just got it. So let me just read it. Democracy, not what a majority of people. I will read. I will read, David, if you allow me the question. So democracy is not what a majority of the people want, but what 15 unelected, unaccountable judges think it's reasonable. Not based on precedent, not based on existing legal principles, not based on examples from other countries. Well, democracy is not majority rules. A democracy works by a majority rule, but democracy means that you have values, that you have rule of law, that you have an independent judiciary, that you have a protection of human rights, and then you have free elections. This is democracy for me. It has like a table with 5 legs. And somebody must control or limit the power of the majority. Otherwise, the majority can do terrible things to a minority. And I think we all know that very well from our history. And yes, the one that has to limit the power of the majority is somebody else, somebody that we call the guardian of the Constitution. And we have many models and many systems for choosing the guardian of the Constitution. Our judges, luckily, are not elected by politicians. They are elected by a committee that has all the branches in it. It's not perfect, but it's the way that numerous countries are going there lately, Ireland, England. And that's the way Israel works. I wish we had other kind of checks and balances. Perhaps 2 houses of parliament, perhaps veto power, perhaps another way of elections, regional elections, federal state, but we don't have anything in that. It means that in Israel, 61 is absolute power. And the court is the only branch, actually, that can limit the power. That's it. That's my answer.
Let me just add one perspective from HIDDUSH's surveys, consistent surveys. We ask the question, and actually IDI asks a comparable question as well, but we ask the question, which of the following arms of government do you have high trust in? And we list 4: the Knesset, the government, the Supreme Court, and you'll understand this is what Hiddush is very much about, the Chief Rabbinate. Putting the Chief Rabbinate aside, it has very little trust attached to it by the public. But the important thing to understand, David and everyone else who is still with us, 4 times more adult Israeli Jews express high level of trust in the Supreme Court than in the Knesset. Altogether, there is a problem, and many don't have trust in any government institutions. This is very sad, and it's part of the erosion that Professor Navot was alluding to, that we really need to overcome. But understand that of those who have trust in public institutions and the arms of government, it is the Supreme Court that has 4 times more trust of the public than the Knesset. And with that in mind, I think that what you say, David, theoretically sounds great, though I agree, of course, with Professor Navot as to the history lessons involving the abuse of democracy. But please understand that is not how the public feels. Well, do you want to have the last word?
Yes, one last question, Adriana. What about redefining the core values of Jewish in terms of separating the religious aspect from the core values of the state and make it secular Jewish democratic state. That could be done and changed. That's a very difficult question. I'm afraid not. Not for the moment, and not from what I see for the future. We try to keep a balance between Jewish and democratic. I do not see a separation of the state from religion in Israel. 75 years we did not have. But we need another social contract, that's for sure. The exemption of the yeshiva students from the army, and the money that they get and from the people that serve in the army in order that goes to the yeshivas in the budget. That's something that the people is not ready to cope with anymore. So I hope the politicians will understand that. All politicians, I think, and especially the Haredim, will understand that something must be done in order to keep living together. For me, I think the togetherness is very important. For me, this is a Jewish and democratic country. I love it as it is. I do not want 100% democracy and zero Jewishness, and not the opposite. I think a balance is a good balance. We have managed with this balance, but something in the last, I think, years has gone wrong. And it's not for the court to make this balance. It's for the Knesset, for the politicians, to think about a new deal, a real new deal. And this is what people are talking about, especially after the protests over the judicial overhaul. And hopefully we'll have a government that thinks about the welfare of all the people, even those who did not voted for it, and will think about the question that you pose. I do not see it as a secular Jewish state. I think Bnei Brak will be religious, and some parts of Jerusalem, and Bet Shemesh, and etc., etc. And it's okay with me. Live and let live. I think that's the only, I think that's the only motto for a good balance between Jewish and democratic. Not 100% democratic. We will never be. But we will never be 100% Jewish as well. And thank you. It's a very good question. It's a question for thinking. I'm sure Uri will take it from here for his next. And thank you all. Steve, it's a pleasure to see you again. And some of you I remember from my last, 10 years ago when we met. A year here is like, 10 years usually. Thank you for all what you have written, and for your thanks. And I think I wish you all a good times, better times for Israel. Keep fighting for Israel, even if you're there. We are still here, and we will fight for our country, fight for democracy, and fight for our security. Thank you again.
Thank you, Professor
Can I say
Navot.
goodbye?
Thank you all for joining us, and we hope to see you again next month. Shalom, and bring them home now.
Yes,
That
indeed.
is what we all are adding to our prayers and hopes. The events of today were exciting, but we just have to hope that this is not the end, but rather it'll herald more releases of more hostages. Shalom, until next time.